extradite or prosecute provisions. A convention along these lines would fill a gap in international criminal law. The Commission is expected in 2014 to decide on the inclusion of the topic in its current programme of work in the light of reactions of states in the Sixth Committee. So again, this is a matter on which your views would be much appreciated. I now turn to the first of the three topics highlighted for the agenda today, immunity of state officials from foreign criminal jurisdiction. This is politically a very important and sensitive topic, and it's one on which there are quite different views among members of the International Law Commission. And I very much hope that government lawyers, including those represented on ALCO, will follow the topic closely and will comment in the Sixth Committee and respond in writing to the Commission's questions. This year we adopted 3 draft articles, Articles 1, 3 and 4. Draft Article 1 defines the scope of the topic, which, as I've said, concerns immunity from foreign criminal jurisdiction. The topic does not cover the vexed question of immunities before international criminal courts and tribunals. Article 1 also makes it clear that the draft is without prejudice to the immunity enjoyed by diplomats, consuls, persons on special missions, and others who are governed by special rules of international law. I need to say a word about special missions. The Commission's commentary stresses the practical importance of the law on special missions, both under the 1969 New York Convention and under customary international law. There have been a number of recent cases in this field, including one in the English High Court, which confirmed the customary law status of the immunity of persons on special missions. This is of practical importance because it means that senior officials may enjoy personal immunity from foreign criminal jurisdiction, even if they do not fall into that narrow circle of high state officials who enjoy immunity ratione personae by virtue of their office. And this brings me to the main outcome of the Commission's work on the topic this year. The endorsement in Article 3 of the so-called Troika, heads of state, heads of government, and ministers for foreign affairs, as enjoying immunity ratione personae, that is, full immunity during their term of office. This was a compromise, and there remain 1 or 2 members of the Commission who do not agree that foreign ministers should have such immunity. For example, in other words, they think that the International Court was wrong in the arrest warrant case. And there are others on the Commission, including myself, who think that the narrow circle of persons concerned should not be confined to the Troika, but should include, for example, defense ministers and ministers of international trade. But the Commission has come up with this compromise, which it's proposing to governments, that immunity ratione personae be confined to, or should apply to, the Troika. The next stages of this topic will be even more complex. Next year we shall be looking at questions relating to official act immunity. And then, probably the year after, in 2015, we'll come to the politically most sensitive question of all, of possible exceptions to immunity. For example, for core crimes of international concern. And there are some on the Commission who think that even the immunity of the Troika, of heads of state, heads of government and foreign ministers in office, should be subject to exceptions for core crimes. I am not one of them. The second topic is protection of persons in the event of disasters. The Secretary General has already described Mr. Valencia Ospina, the Special Rapporteur's 6th report on this subject. It deals with disaster risk reduction. That's eminently practical matters, the need to take steps to avert disasters before they occur and to make preparations so they can be dealt with as effectively as possible if and when they do occur. The report contains a great deal of information and draws on a wealth of texts and documents. It gave a sound and solid basis for the articles that the Commission adopted this year. However, I have to say that the section of the report dealing with prevention as a general principle of international law was quite heavily criticized. The Special Rapporteur on this subject plans a final report next year, so by the end of the session next year we should have a complete first reading set of draft articles on this important subject. And finally I come to the topic formation and evidence of customary international law, for which I happen to be the Special Rapporteur. The topic has now been renamed, for rather obscure reasons, identification of customary international law. Essentially, the earlier topic didn't translate very well into the other languages of the United Nations. The work this year on this topic was of a preliminary nature, and no draft conclusions have yet been adopted. But there was agreement, I think, that the outcome of the Commission's work should be practical. The aim is to provide guidance for anyone, perhaps particularly those who are not expert in the field of public international law, like domestic judges or private lawyers who are not specialists in this field, who nevertheless are faced with the task of determining whether or not a rule of customary international law exists. And it seems to be widely accepted that it's not our task to seek to resolve theoretical disputes about the basis of customary law, to examine in too much detail the various approaches found in the literature, but to come up with practical conclusions that will help judges and others reach decisions on the matter. And it's not our aim to come up with hard and fast rules, but rather a set of conclusions with commentaries, because it's important to retain flexibility with this source of international law. As Mr. Huang, the Chinese member of the Commission, said, we need to strike a balance between certainty and flexibility. And I very much agree with the way the Jordanian member of the Commission, Mr. Hamoud, put it. He said that even if the Commission merely describes the current state of the law without adopting a set of conclusions, through adopting a set of conclusions, such conclusions will definitely advance the rule of law and a clear understanding of what is part of customary international law and what is not. That is very much the aim, to bring more certainty to this difficult issue. The Commission decided that we should not deal with jus cogens, peremptory norms of international law, as part of the present topic. But there is a proposal from one member of the Commission that we should have a separate topic on that interesting subject. As Dr. Mohammed has just explained, the debate this year in the Commission was based on two papers. The first report, which I prepared, and an excellent Secretariat memorandum, which described elements in the previous work of the International Law Commission that could be relevant to the topic. That memorandum is of very high quality, as we've come to expect from the UN Codification Division. It contains a wealth of learning, information, and insight, It covers the Commission's general approach, its approach to state practice, its approach to the subjective element, opinio juris, the relevance of the practice of international organizations, such as resolutions of international organizations, and the relevance of judicial pronouncements and of writings. Importantly, the memorandum found that the Commission's practice in identifying the existence of a rule of customary international law reflects the widely accepted two-element approach. In other words, you have to look for state practice and for opinio juris. In the literature, quite a lot of writers adopt what they claim to be a modern approach to customary international law, which means you just look at what states say at opinio juris. Others take the view you just look at what they do, state practice. But the Commission has reaffirmed, the Commission this year and also in the past has reaffirmed the two-element approach. The Secretariat paper succeeds in distilling a coherent set of observations from the work of the Commission over a long period, which encourages me to think that it may indeed be possible for the Commission itself to conduct a similar exercise on the much broader canvas of the materials listed in my first report. In that first report, I said that the most important materials were state practice. How do states themselves look for customary international law? That's actually quite difficult to discover because they usually don't explain how they look for customary international law, but just occasionally they do. Reactions, for example, to the ICRC study of customary international humanitarian law give an indication of how states approach the matter or may approach the matter. Among other things, the report deals with the relationship between customary law and other sources of international law. The relationship between customary law and treaties is a matter of great practical importance and I think is reasonably well understood. There's a lot of case law and a lot of writing. Less obvious, less studied, and perhaps less well understood is the relationship between customary international law and general principles of law within the meaning of Article 38(1)(c) of the International Court Statute. The report sets out at length with examples the range of materials that the Commission may need to take into account. And it tries to highlight the general approach that these materials reveal. I think virtually all of the materials stress the need for both state practice and opinio juris. And the International Court of Justice in particular has clearly and consistently held that customary international law is formed through state practice accompanied by opinio juris. The topic, as I see it, is very much a collective effort. We have requested states to provide by 31 January 2014 information both on their own approach to the formation of customary international law and also on case law and materials that they may have in their own countries. It's very important that we can draw on case law from all regions of the world and all the principal legal systems of the world. But in order to do that, we really do need your assistance in providing us with the basic materials. Conferences like this one and academic conferences can play an important part. The Council of Europe, together with the government of France, organized a very interesting conference in Paris last September on the judge and international custom. The proceedings are published, and a number of distinguished judges spoke. In particular, the President of the International Court of Justice, President Tomka, gave a very interesting paper which is available online. Madam President, one of the aspirations of ALCO, as I understand it, is to ensure that the voice of Asian and African states is heard loud and clear in the progressive development